Good afternoon, Vande Mataram, Jai Hind. I hope you have watched the previous videos before watching these videos, and don't forget to like, subscribe channel and click on the bell icon to get the notification of new videos on time. Today we are going to learn about the President and Vice President of the India. So without wasting time, let's start. So the President, for President, the Article 52, 53 and so on. So the Article 52 says there shall be a President of India. That means there should be one President for the India as a country. The Article 53 says the executive power of the Union. That means the Union government. The Union executive power shall be vested in the President and shall be experienced by him either directly or through officers subordinated to him. That means the Union government is headed by the President, but he is the nominal head and the actual head is the PM of the country. All the exercise that happen are by his signature either directly or through the officers subordinated to him. He is the supreme commander of the defense forces in the India. We all know that. Though he is only the constitutional head or titular head, de jure head or nominal executive or just a symbolic head. That means in India we have the President, Vice President, the Prime Minister, that type of government, but the President is the nominal head or the constitutional head of the country, but the actual governing of the country is done by the Prime Minister. Then comes the elections of the President, how the President is elected. The President shall be elected by the members of the electoral college of the consist of. That means the President is elected by one type of member company. That means we can say that there are the elected members are who elect the President. The election goes on for that. So who are the electoral college consist of? The elected MPs, the elected MLAs of the states, the elected MLAs of the National Capital Territory of Delhi, added by the 17th Amendment Act 1992, and the Union Territory of the Puducherry. Then comes the nominated members of the Parliament and the Legislative Assembly, and the members of the Legislative Council do not participate in the presidential election. That means for the nomination of the President, the people that we citizens of India, we nominate that persons or that members are only eligible for the nominating members of the Parliament, not any other. Then comes the Article 55. Provide the manner of election, there should be uniformity and the representation throughout the nation as per the Constitution. Hence, the MPs and MLAs has been assigned votes as per their representation. Then the election is held in accordance with the system of the proportional representation by means of single transportable vote, and the voting is done by the secret ballot. That means the election for the President is done by single transferable vote and by a secret ballot. All doubts and disputes arising out of the presidential election are decided into and inquired by the Supreme Court, whose decision is final. That means all doubt disputes regarding the presidential elections are done or inquired by the Supreme Court, and the decision of the Supreme Court is final. You cannot go beyond that. The elections are mentioned and conducted by the Election Commissions of India. That means for the elections there is some type of commission. That commission is named as the Election Commission of India. Then comes the only one president, that is the Neelam Sanjeevan Reddy, has been elected unopposed so far. That means there was no any opposition party for the presidential. Only one president has been elected without any opposition, and the name is the Neelam Sanjeeva Reddy. Then the Dr. Rajendra Prasad has been elected for the 2 times. Now, 2 presidents, Dr. Zakir Hussain and the Fakhruddin Ali Ahmad, have died in the office. Then how the MLAs votes, the values of MPs, the equal quota has been calculated is given by the 3 formulas. You can go through this. Then comes the terms of the office. The President is elected for the 5 years, and the resignation of the President is given to the Vice President. The President's president is eligible for the re-election for any number of times. That means the president is elected for the 5 years, and if after the 5 years, if he wants to again stand for the president election, he can. That means the re-election of any number of times. Then the qualifications and the condition, the oath for the election of the president. The eligibility for the election in the president are: he should be a citizen of India, the first and most for all types of government sector. Then he should have completed the 35 years of age. He is or she is eligible for the election of MPs of the House of the People. That means Lok Sabha. He has to be eligible for the election of the Lok Sabha. Shouldn't hold any office of profit. We will discuss the office of profit laterwards. The president shall not be a member of either house of the parliament of any legislature. If such a member is elected, he is deemed to have vacated that seat. That means president has to be eligible for the Lok Sabha or Rajya Sabha. That means the House of People. But if he is the member of any house, and after getting the elected as the president, he has to vacate his seat. That means he has to leave that seat and acquire the president leadership. What is the office of profit? The office of profit means an office to which some benefit is derived. The actual making of profit is not necessary. The profit means pecuniary gain or any material gain derived from the office. Profit may be received in the form of salary, remuneration, etc., not as an honorism. That means office of profit means if you are a civil or the government employee and you are also having a company where you get the profit, any type of money or salary, that is the office of profit. If you are getting the monthly salary from the government and also by the private sector, this is the not allowed in the election of the president. That is the office of profit. The rationale of office of profit: the object of article 1021A and 1911A is that there should not be any conflict between the duties and interests of an elected member, and to see that such an elected member can carry on freely, fearlessly his duties without being subject to any kind of government pressure. The nomination of the candidate for election must be subscribed by at least 50 electorates as a processor and 50 electorate as a seconder. That means he should have the 50 electors. That means we say that 50 his own party, his own company should have at least 50 processors and 50 electors as seconders. Though administered by the Chief Justice of India or in his absence the senior most judge of the Supreme Court available. For the oath, the oath ceremony we all know for the president or the CA. For the president, the oath is administered. The oath is given to the president by the Chief Justice of India or in his absence the senior most judge of the Supreme Court. The allowances and the privilege etc. are as may be determined by the parliament, which can't be diminished during his term. That means if the salary or the allowances are once derived and given to one president, all 5 years it is same. You cannot alter change it. He is immune for any criminal proceeding during his term. He cannot be arrested or imprisoned. However, after 2 months notice, civil proceedings can be initiated against him during his term in respect of his personal acts. You get that? The impeachment process of the president, it is in the Article 61. A formal removal of the president from his post by constitutional means. Impeachment process for the removal of the president. Impeachment means the removal of the president by means of the constitutional. He is impeached for the violation of the constitution. However, the term is defined nowhere in the constitution. The charges can be preferred by either house of the parliament. However, a 14 days prior notice should be given to the president before the acceptance of such a resolution for the inconvenience or whatever he has to say for the charges that he got. Also, that notice must be signed at least 1/4 member of the total members of that house which initiated the charge. That means at least 1/4 members of the parliament or the house should be signed this charge impeachment process. Then this process starts. After the acceptance of the bill in that house, that impeachment bill must be passed by the majority of 2/3 of the total membership of that house. For the initiation, 1/4 member has to sign, and to pass the bill, at least 2/3 of the majority has to allow that, pass that bill. Then that bill goes to another house which should investigate the charges, and the president shall have the right to appear and to be represent the investigation. If another house sustain the charges and find the president of violation and pass the resolution by 2/3 of the total membership of that house, the president stands removed from the date of the resolution is passed. That means if one house passed the bill by 2/3 of majority and the second house also passed by 2/3 of majority, then the president is removed from the duty from the date the second house also passed that bill. Hence the impeachment process is a quasi-judicial process, and though the nominated members of the parliament do not participate in his election, they take part in the impeachment process. Also, state legislature do not have the role in the impeachment process. That means for the impeachment process, whoever participated in the election of the president are not eligible to have participate in this impeachment process. Then comes the vacancy. In case of the resignation or the removal of the date of the President of India, the Vice President of India will be the acting President. If the Vice President of India is not available, then the Chief Justice of Supreme Court, and his absent, the senior most judge of the Supreme Court will be the acting President of India. The election needs to be done within the 6 months of the vacancy of the office. The powers of the President, the executive powers. What are the executive powers? The other financial powers and other powers. We will discuss one by one. First of all, the executive powers. All executive actions are taken in his name. He is the formal constitutional titular head or de jure head of the government. That means he is the supreme commander of all the union government. He appoints the prime minister and other ministers on the PM's, that means prime minister's advice. Appoints the attorney general of India, the CAG, the Chief Election Commissioner and other commissioners, the chairman and the members of the UPSC, the governors of the states, chairman and the members of the Finance Commission, etc. He appoints interstate council, and he is the one who can declare any area as scheduled area and decide on the matter of the declaration of any tribunal as the scheduled tribe. He can appoint a commission to investigate into the conditions of the SC, STs and other backward classes. Then comes the legislative power. He summons and prorogate the parliament and dissolve the Lok Sabha. That means he can allow or request the members of the Lok Sabha to come and have a sitting, or dissolve the Lok Sabha as well. They summons the joint sitting of the two houses of the parliament, which is presided over by the speaker of the Lok Sabha. There has to be a joint sitting if any bill is not passed by the other house and passed by the first house, but there should be have some misunderstanding or miscarriage. Then the president asks both the houses to have a joint sitting to discuss on the particular bill or matter. This joint sitting is prescribed by the president, but after that the presided over by the speaker of the Lok Sabha. There is some definition of the term summoning, adjournment, sine die, prorogation and dissolution. The adjournment means the termination of the sitting for indefinite period. That means adjournment means if I am conducting a meeting and after finalizing or concluding the meeting, I do not say a word about the next meeting when will happen or anything for the given time. The prorogation means terminate the session for a given period of time. That means after completion of the meeting, I will say that tomorrow or next week, this day and this time we will meet again. That means prorogation. Dissolution means terminates the life of the house. That means the suppose the Lok Sabha has been dissolved, we all heard about it. That means the life of that house is completed and he terminates the life of the house. Nominates 12 members to Rajya Sabha from among the people having the achievements in art, literature, science and the social science. There was a provision for nomination of 2 members from the Anglo-Indian community to Lok Sabha, which was removed after passing of 104th Constitution Amendment Act by the Parliament recently in December 2019. The reservation for Anglo-Indian community and the related provisions in Article 334 have expired on January 25th, 2020, as the bill does not extend the facilities to the community. His prior recommendation is required in case of representation of certain types of bills such as money bill, bill seeking expenditure from the consolidated funds of India. If any bill, the money bill, has to be presented before the Lok Sabha, then prior recommendation of the President is required. Also, for nomination of he nominated 12 members in the Rajya Sabha, and earlier it was 2 members in the Lok Sabha, but the 104th Constitution Amendment Act removed that part, 2 members in the Lok Sabha. He can withhold his assents to bills, return the bills to the legislation and apply the pocket veto. We'll learn about this, the powers which the President have. He can promulgate ordinance when the Parliament is not in session. He present the report of Finance Commission, CAG, UPC, etc. before the Parliament. That means all the reports and audits given by the Finance Commission, CAG and the UPSC and others, he is the one who represent them in the Parliament. No demand for the grant can be made except for his recommendation. Also, he constitutes a Finance Commission every 5 years for distribution of revenues between the centre and states. Then comes the judicial powers. Appoint Chief Justice and other judges of the Supreme Courts and the High Courts, seeking advice from the Supreme Court on any questions of law. He can grant pardon. That means just giving a pardon. You are giving a less sentence or less duration of the sentence. That type. The emergency powers. We all know that President is the one who can sign any type of the emergency happening in the nation, in the state or in the financial. There are only 3 types: national emergency, state emergency, that is the presidential emergency, and the financial emergency. The national emergency is given in the Article 352. National emergency is declared under the circumstances of war, external aggressions and armed rebellion. National emergency is declared by the President only on the written request of the cabinet ministers headed by the Prime Minister, and the proclamation must be approved by the Parliament within the 1 month. The written recommendation is the one and majority asked in the exam various times that who declares the national emergency. The President declares the national emergency only after the written request of the cabinet minister headed by the Prime Minister. The national emergency can be imposed for 6 months. It can be extended by another 6 months by repeated parliamentary approval for an indefinite period. That means if President wants the national emergency to be increased for along more 6 months, then he just follows the same process from the start. The bill passed by the Parliament within 1 month, and he can the national emergency goes for indefinite period of time. Under national emergency, the fundamental rights, the FRs of the Indian citizens could be suspended. 6 freedoms under the right of freedom are automatically suspended. The right to life and personal liberty can't be suspended. Then there has been 3 types of emergencies, and the national emergency has been invoked at 3 instances: 1962 India-China War, 1971 Indo-Pakistan War, and 1975 to 1977 Declaration Accounts of the Internal Disturbance. Then comes the President's rule, Article 356, State Emergency. The state emergency is imposed by the following provisions. The constitutional machinery of the state has been fed under the Article 356. That means the constitution has given some points that state has to follow, and if the state is not following that points, then this type of emergency imposed on that state. If the state isn't working according to the given directions of the central government, then the article 365 gives the state emergency on the following states. Such emergencies must be approved by the parliament within the period of 2 months. It can be imposed from 6 months, maximum period of 3 years, with repeated parliamentary approval for the 6 months. That means if the president wants to increase the state emergency, he can increase the state emergency for another 6 years by following the same method, but for 3 years of period maximum, and for the national emergency indefinite period. That's the difference. The emergency can be extended if needed for more than 3 years by the constitution amendment, as done in the case of the Punjab Jammu Kashmir. Then comes the beyond 1 year, president's rule can be continued for by every 6 months by meeting the following condition. There should be already a national emergency in the country, in the world, or whole or the part of the country. Second, ECI should be certified that the conduct of the election is not possible in the concerned state. That means if the president's rule can be continued for 6 months beyond 1 year by the following condition. That means if they in a country, in India, if the national emergency is invoked, or the election commissions of India should certify that in a particular area the election will not be possible for the concerned state. During such an emergency, the state is administered by the governor in the name of the president. The legislature assembly could be dissolved or may remain in the suspended animation. The parliament makes law on the 61 subjects of the state list. The money will have to be referred to the parliament for approval. Such type of emergency has been imposed in India hundreds of times, and the first time it was imposed in the state of Punjab. Then comes the Article 360, the financial emergencies. It has never been happened in India, the financial emergency, so I don't think that it is a much greater topic, but the president can proclaim the financial emergency if the financial stability or the credit of India is threatened. This proclamation must be approved by a simple majority in the both houses of the parliament within 2 months. Once approved, it continues indefinite, no max period, without the repeated legislative approval. President can revoke this proclamation anytime. This doesn't need parliament's approval. The financial emergency has not been declared in India so far. That was the emergencies that has been inducted, or how the emergency, national emergency, the presidential emergency, and financial emergency happen in India and given in the Constitution of India. It is all covered in the part of 18 of the Indian Constitution. Then the veto powers. The Indian president have 3 types of veto power: the absolute veto, the suspensive veto, and the pocket veto. The fourth one is the qualified veto, but it is not for the Indian president. So we will discuss them one by one. The absolute veto, withholding the asset to the bill. The bill then ends and does not become an act. The president may use the absolute veto in the following 2 cases. That means if any bill has been passed by both the houses of the parliament and comes to the president's signature or the assent, then he can either use the absolute veto. That means he just withhold the bill, his assent on the bill, and does not pass it. Then the bill ends there and does not become an act. If the bill passed in the private member bill, if the cabinet resigns before the bill could get the assent of the president. The new cabinet may advise the president not to give that bill his assent. For example, in 1954, Dr. Rajendra Prasad withheld his assent to the PEPSU appropriation bill. Also in 1991, R. Venkatraman withheld his assent to the MP's salaries and allowance bill. That was for some examples. Then comes the suspensive veto, returning the bill for the reconsideration. That means if the both houses pass the bill and the bill comes to the president for his assent, but the president feels that there has to be some minor changes or the changes in the bill, then he returns the bill for the reconsideration with some minor changes. However, the president can return the bill for the reconsideration to the parliament only once, after which he has to give his consent without using any of his veto powers. Also, while receiving the bill to the president, parliament has to pass it by the ordinary majority only and not by the high or special majority. We will discuss the majorities, how the ordinary majority, the special majority, the effective majority after this video. For example, the suspensive veto. For the example, in 2006, the President APJ Abdul Kalam used the suspensive veto in the Office of Profit Bill. Note, the American presidents exercise the power of qualified veto that I told you, which is similar to the suspensive veto in terms of application, but it is comparatively more powerful than the latter, because once returned by the US president, the bill must be approved by the 2/3 majority of the both of the house to get his assent. Then the pocket veto, the last veto used by the President of India, taking no action on the bill sent to the president. There is no time limit provided in the constitution within which the president has to give his assent or sign the bill. Hence, he has a bigger pocket than the American president. The American president has to act upon the bill within the 10 days, but the Indian president has no such limitation. For example, in 1986, the President Zali Singh applied pocket veto in the Post Office Amendment Bill. Note, the President has no veto power in case of the Constitution Amendment Bill. He is bound to give his assent to such bill. The 24th Constitutional Amendment Act 1971. That means for any type of bill, he can use the pocket veto. But the Constitution Amendment Bill, in that matter, President have to give some types of assent. Ordinance making powers, the President's having the Article 123. An ordinance can be issued by the President only when both the House of the Parliament are not in session or when only one House is in the session. The ordinance must be approved by the Parliament within the 6 weeks of its assembly. Hence, the maximum life of the ordinance is 6 months plus 6 weeks. He can issue the ordinance only on the advice of the Council of Ministers headed by the Prime Minister. Then the financial powers of the President. The money bill can be introduced in the Parliament only with the recommendation of the President. The President can make the advance out of the contingency fund of India to meet the unforeseen expenses. The President appoints the Finance Commission after every 5 years to recommend the distribution of the taxes between the center and the states. These are some financial powers of the President of India. Then the pardoning power of the President under the Article 72. The President has the power to grant pardon, reprieve, commutation, remission, respite to any person convicted in any union law or by a court martial or in case of death penalty. It is an executive power, and the governor also have those powers under Article 161. However, the governor can't pardon a death sentence, nor can be intervened in the court martial cases. That means the governor also has some pardoning powers, but if a person is given the death sentence or the court martial cases, the governor has no pardoning power. The President exercises this power on the advice of the Union Cabinet. Then the pardoning power of the President includes the following: the pardoning, It removes the both sentence and the conviction completely, absolve the convict from all sentences, disqualification and the punishment. Pardoning means just he is not that criminal, and removes all the sentence and the conviction. The commutation we have already discussed in the previous videos as well. The commutation means it denotes the substitution of the harsher form of punishment from a lighter. For example, if the death sentence may be commuted to the rigorous imprisonment, which is turn may be commuted to a single imprisonment. In short, the commutation means a lighter form of punishment. Then comes the remission. It implies reducing the final period of the sentence without changing the character of it. For example, a sentence of rigorous imprisonment for 2 years may be remitted to the rigorous imprisonment for 1 year. In short, remission means giving a reduced period with the same sentence. The respite means it denotes towards the awarding the lesser sentence in the place of originally awarded due to some special circumstances. For example, a pregnancy of a woman offended or a physical disability of a convict. The reprieve means it implies a stay on the execution of the sentence, especially that to the state. Reprieve means just stop the punishment for some time, especially for the death punishment, for a temporary period. Its purpose is to enable the convict to have time to seek the pardon or the commutation from the president. Then comes the discrimination powers of the president. He appoints the prime minister with no party has a clear majority in the Lok Sabha, or when the prime minister in office dies suddenly and there is no obvious successor. Disassemble of the council of ministers when it can't prove the confidence in the Lok Sabha. The dissolution of the Lok Sabha if the council of ministers has lost its majority. Use the suspensive veto in the cases of bills. We already discussed about that. The constitutional immunity to the president. The Article 361 is an exception to Article 14, the right to equality of the Indian Constitution. The features are as follows. The president or the government is not answerable to any court for the exercise of the powers and the duties of his office. That means if the governor or the president is following his duties and exercising his power, then he is not answerable to any court. No criminal proceedings shall be conducted against the president or the government during his term of office. No arrest or imprisonment shall be made against the president or governor during his term of office. Civil proceedings against a governor or the president against things done by him in his personal capacity can be done only with the prior 2 months notice. If the civil proceedings against the governor or president is happening or anyone wants to go with that, then the 2 months prior notice has to be given to the president or the governor. The diplomatic powers. The international treaties and agreements are signed on behalf of the president. However, they are subject to approval of the parliament. The president represents India in the international forums and affairs and may send and receive diplomats like ambassadors, high commissioners, etc. The list of all presidents of India that we had. The Rajendra Prasad 1950 to 62, Sarvepalli Radhakrishnan from 1962 to 67, Zakir Hussain 67 to 69, V.V. Giri 69 to 74, Fakiruddin Ali Ahmad 74 to 77, Neelam Sanjeeva Reddy 77 to 87, Zali Singh 82 to 87, Ramaswamy Venkatraman 87 to 92, Shankar Dayal Sharma 92 to 97, K.R. Narayana 97 to 2002, APJ Abdul Kalam from 2002 to 2007, Pratibha Patil from 2007 to 12, Pranab Mukherjee 12 to 17, and now the Ramnath Kovind from 2017. Then comes the Vice President. The Vice President is not a member of either of the House of Parliament or of House of the Legislature of any state. If a member of the Lok Sabha or Rajya Sabha or the House of Legislature of any state is elected as a Vice President, he is deemed to have to vacate his seat That means if vice president is getting elected from the house of the Lok Sabha, member of the Lok Sabha, Rajya Sabha or Legislative Assembly, then he has to vacate his seat in that part and continues his vice presidentships. The election of the vice presidents under the Article 66. The election of the vice president is slightly different from the election of the president. So what are the conditions for that? The vice president is elected by an electoral college consists of all members of the both houses of the parliament, including the nominated members. The election is held in accordance with the system of proportional representation by means of single transferable vote, and voting is done by secret ballot. Note: members of the Legislative Assembly of the state do not participate in the election of the vice president. That's the difference. The comparison between the electoral college of the president and the vice president. Members who participate in the election of the presidents are elected MPs, elected MLAs of the state, elected MLAs from Delhi and Puducherry. But for the vice presidents, all elected and nominated MPs only. Members who do not participate in the election of the president, the nominated MPs, MLAs, members of the state legislative council. In the vice president, all MLAs from the state legislative assembly, both elected and the nominated members of the state legislative council, are not participating in the election of the vice president. Then comes the qualification, conditions and the oath for the vice president. He must be, first and the most important condition and eligibility is he has to be the citizen of India. He must attain the age of 35 years. He is eligible for the election as a member of the Council of States, that is the Rajya Sabha. But for the president, he has to be eligible for the election as a member of Lok Sabha, and for vice president it is Rajya Sabha. Shouldn't hold any office of profit, that we have discussed what is the office of profit earlier. All the disputes regarding the election of the vice presidents of India are looked after by the Supreme Court of India, similar to the president. He is elected for the 5 years of periods and he can be re-elected for any numbers of time. However, he can resign before 5 years by handing over his resignation to the president. The other ways where the vacancy is created in the office of vice presidents are given below. When he completed his terms of 5 years, when he resigned, when he is removed on his death, when his election is declared void. These are the terms when the vice presidents vacate his seat. He take oath in the presence of the President of India. He gets a monthly salary of 4 lakh per month and gets a 50% pension after the retirement. That's not that important in the point of exam view. He gives his resignation to the President of India. He can be removed from his office by the resolution of the Rajya Sabha passed by the absolute majority. That is the majority of the total members of the house. We will discuss about the absolute majority, the effective majority and all other majorities in one video. And if it is agreed by the Lok Sabha, the vice president is removed from his office. Notably, the constitution does not list grounds for the removal. The procedure for the impeachment is not required in case of the vice president of India. That means for the president of India, the process is impeachment process for the removal of the president, but for the vice president it is not there. The vice president of India, unlike the president, can hold the office beyond his term of 5 years unless its successor takes charge. No vice president has ever faced the removal. That means until today, no any vice president has been faced the removal from his term and his office. Then comes the powers of the vice president of India. The vice president of India is the ex officio chairman of the Rajya Sabha, but since he is not the member of the Rajya Sabha, he cannot vote. That means, like in the Lok Sabha, we have this speaker of the Lok Sabha. Similar to the Rajya Sabha, there is the chairman, but the chairman is the vice president always, and as he is not the member of the Rajya Sabha, he cannot vote in any type of bill. He acts as a president of India in case of the death, resignation, removal, or the illness of the president of the India. During that time, he is not the present in the Rajya Sabha and he gets the salary of the president of India. All the bills, resolution and motions can be taken in the Rajya Sabha after the consent of the Vice President of India. These are some powers of the Vice President of India, not that much, unlike the President of India. Then the India's Vice Presidents from the starting: 1952 Sarvepalli Radhakrishnan, 57 also Sarvepalli Radhakrishnan, 1962 Zakir Hussain, 67 V.V. Giri, 69 Gopal Swarup Pathak, 74 B.D. Jatti, 79 Muhammad Hidayullah, 84 Ramaswamy Venkatraman, 87 S.D. Sharma, 92 K.R. Narayana, 97 Krishna Kant, 2002 B.S. Shekhawat, 2007 Muhammad Hamid Ansari. Also in 2012 Muhammad Hamid Ansari. And for you, from the 27 you have to give the answer who was the Vice President, who is the Vice President from the 2017 in the comment section below. So friends, we have covered the all points for the presidents and the vice president in the Constitution of India. The president come in the article 52 to 78, the emergencies 352, 356, 365 and 360, and for the vice president the article 63 that we have discussed everything all about this. I hope you have liked, shared and subscribed to my channel, and also clicked on the bell icon to get the notifications of the new videos on time. So that's it for today. We will meet tomorrow in the same time. Thank you for joining me on this channel. Have a good day.